Let's get into this conversation now. The Department of Correctional Services has hit back at convicted rapist and murderer Thabo Bester's claims of inhumane conditions at the Kgosi Mampuru Correctional facility. The department says the treatment he's receiving is consistent with what is prescribed by the Correctional Services Act for a maximum classified inmate. Bester claims that he is placed in solitary confinement for 23 hours per day and has no access to resources to prepare for his trial. But the Department of Correctional Services says this is disingenuous as he's being held in a single cell. It also says Bester cannot be given electronic devices as it poses a security risk to the center and might enable him to orchestrate another escape. All right, let's get some analysis now on prisoner rights, and we're joined by legal analyst Melusi Xulu. Mr. Xulu, good evening to you, and thank you very much for your time. Let me begin with the question that seeks to find out what would constitute inhumane treatment for a prisoner who is being kept in a single cell.
Good evening to you, Putol, and to the viewers at home. Thank you for inviting me. Inhuman conditions will be conditions where, obviously, if it's a solitary confinement, that will be inhumane, where it's possible for him to have cellmates. But in a statement that was made by the Department of Correctional Services, they've stated that the prison center where it's located in Pretoria basically is where it's a single cell, so you can't have cellmates. So he can't say it's inhumane for him to be in a solitary confinement. Furthermore, if you look at Section 11 of the Correctional Services Act, it states that you have at least an hour to exercise per day of the 23 hours. So if you are confined to 23 hours alone, you can have an hour to exercise. So with regard to solitary confinement, I think if what the department has stated is what is happening, it's not solitary confinement per se, but it's just basically a single cell arrangement for everyone, not just for Thabo Bester.
I listened to his lawyer this afternoon arguing vigorously that his mental state is important. It's something to consider. Would that count as a legitimate challenge?
Well, it does count. Even internationally, it's recognized that solitary confinement is not something that is, appreciated. But I suppose it will depend on the argument that will be made by his defense or his advocate about whether it is really true that that the prison is a single cell prison, rather than what they're trying to say, because he basically doesn't want to be in a single cell, but the prison is saying this is actually a single cell arrangement. So solitary confinement by default is something that is going to happen whether you like it or not.
I then listened to the argument against, which was countering Bester's lawyer, and the lawyer was saying that it is disingenuous for at least Mr. Bester to be allowed access to devices, because we know that part of the reason he is in this situation right now is in part because of access to gadgets, which would have presumably allowed him. This is, of course, still being investigated, so we can't talk conclusively or definitively, but this would have presumably allowed him to communicate with certain people so that he was ultimately able to escape from prison. And so the prison authorities are very aware that these gadgets are the very same tools that he could potentially use to escape again. The argument, though, is that if he says he needs to be allowed access to these gadgets so that he can prepare for his case, the lawyer on the other side is saying, but it's not him who prepares for the case. It is legal representative to prepare for the case. So which of these arguments will obviously win the day here.
All right. If you go to Section 35, subsection 2, paragraph B of the Constitution, it states that every prisoner or a person who's detained or accused has the right to adequate time to prepare for his defense and to be given facilities to, to prepare for defense, which means even in terms of the place where he can be able to consult privately. And it's debatable, though, whether that extends to gadgets, especially for Thabo Bester, because, Putol, I looked at the statement of the Department of Correctional Services. If you go to the last paragraph of the statement, it says the department recognizes, I'm just paraphrasing, the department recognizes that every prisoner, has rights that must not be taken or stripped away from him. But then they say some of those rights can be applied differently depending on circumstances as far as possible. So you can see that the state is saying some of the rights that Thabo Bester wants, they are not willing to give them to him because he might use them again to allegedly escape again. So you can see that the state is trying to say, look, we recognize your rights, we recognize your constitutional rights, but there are some things that we cannot do based on the allegations that you escaped prison. So I think the argument that will fly will be based on the fact that is this a constitutional right that must be protected? And if it cannot be protected, what is the reason for its limitation in terms of Section 36 of the Constitution?
Let's look practically now. Final question to you. So if the department is painfully aware that gadgets are a no-no for Mr. Bester, would reading material, books, newspapers, something like that, is that something that could assist the inmate, at least to cope with the amount of hours that he is sitting in a single cell for hours on end?
No, I think that is possible. But remember that, if it's a laptop, you obviously have access to internet and you have a way to communicate with the outside world. You remember he once had he once had a birthday party that was celebrated, which made as if he was in America. And so the department is aware of how he, when they were sleeping, inverted commas, they are aware that he can use the laptops and gadgets to do things allegedly the way he did them before. So I think with reading material and writing material, that is fine. So with regards to the laptop, maybe that is based on his history. And if I may have a second, the interesting thing about access to laptops is that last year in November, there was a case that said prisoners are allowed to have access to laptops, but it was basically based on Section 29 of the right to education in the Constitution. So in this case, it's based on Section 35, but based on his history, will the court limit that constitution, that right, which can in a way extend to a constitutional right to prepare for his defense? That is why I think the court said today it's better that these arguments are done properly at the right time, because it was premature to discuss those issues today. Then we'll hear from the court whether his rights will be limited or not.
Melusi Xulu, thank you very much for your time and insights here. A legal analyst trying to get us to understand exactly what is being argued by Mr. Bester.